Just looking to see if we have everybody. I think Mr. Anderson, you're still muted.
Can you hear me, Judge?
Okay, now I can hear you. Okay, so do we have, before we go on the record, we have everybody we need? I see, and then Mr., is it Tholstrup? You have to help me.
Judge, that's great. That's great. That's fantastic. It doesn't come out that well normally, so
Okay,
I appreciate that. I only spell it about 50 times a day, Judge.
yeah, I bet. Okay, so that's 2 attorneys and 3 parties. Do we need anybody else here today?
Of course, Judge, I don't think so. You know, on one of these cases, the OAG was a necessary party, but I don't know that they're going to be here for this.
Okay. And okay, but before we get started, so Mr. Tholstrup, so you're now going to represent Ms. Ross on the hearing today?
That's correct, Judge.
Okay, okay.
I've been thrown into the breach.
Yeah, okay. I'm going to go ahead and get started. I'm going to call both cases. First is cause number 2012L-5698 in the interest of Presley Ryan Jones, and cause number 2015L-6399, interest of Briley Machacek. So if I can have
Judge, I'm John Anderson here for Mr. Jones and Mr. Machacek.
And Richard Tholstrup for Ms. Ross.
All right, so Mr. Tholstrup, I've seen you're the new attorney on this case, so this should be your motion. So
It is.
you want any witnesses called or witnesses sworn in?
No, Judge, I don't believe so. Mr. Kingsbury filed both the motions for new trial, and I'd like to address the consolidation issues. You know, there were some ancillary issues in there as well, but I think we'd get lost in the weeds on those. And so I'd like to argue the consolidation issue, Judge.
All right.
May I proceed?
And I tell you what, just before we get started, as I was looking, I saw his motion and went back and, looked at, correspondence and hearings. And since I know, not only Mr. Tholstrup, you weren't involved in the trial, but Mr. Kingsbury wasn't involved in the trial.
Right.
So Miss Dana Baker was the attorney for Miss Ross. So I'll just read some of these in the record. At the end of this, I'll let the attorneys decide if they want to try to get exhibits or evidence or take judicial notice or whatever, but to try to set up a little bit of the timeline that went toward the consolidation is we had a hearing. Mr. Anderson requested an emergency motion for temporary orders. He filed that on January 20th, and it was set on February 11th at 1:30. And so, and then it got reset. So we actually had the hearing on January 28th, 2020. That hearing was at 3 o'clock. And the purpose for that hearing was Ms. Baker filed a motion to deny Mr. Anderson's relief in the temporary orders. So we discussed some of this. It was on the record, so if somebody gets a transcript, they'll be able to see exactly what was said. But at that hearing on January 28th, there was some discussion as to whether or not we should try both cases together or try them separately. During that hearing, Ms. Baker was present with Ms. Ross. Mr. Anderson was present with Mr. Jones and Mr. Machacek. And during that discussion, my memory is that I kind of threw out the idea of, do we need to try two cases or one case? And my memory is, Mr. Anderson can chime in since he was there, but my memory is that Mr. Anderson said that, we should try these cases together. And my memory is Ms. Baker sort of agreed that we should try both of these cases together. And then we eventually did try both cases together. And so I don't think there was any objection to the consolidation. And then we eventually tried the cases. And during the trial, I don't think anybody objected to the cases being consolidated. So in that January 28th hearing, both cases were set for May 4th, 5th, and 6th. But then between January and May is when COVID hit. And that, threw everybody's world upside down.
Right.
So then we had to start resetting things and deciding what we're going to do. And so, again, there's emails that went back and forth. So I would think that, Mr. Anderson has original emails. Ms. Baker probably has original emails, and the court has the original emails. So that's what I'm going to kind of go through the timeline. And then if Mr. Thorstrup, if you need to get copies of these, we can forward them to you, or you can get from Ms. Baker, whatever is easiest. But there was and so I'll try to give the date and time so they'll be as easy as possible to find. But on April 28th, 2020, there was an email from the court, and this was, again, looking at scheduling these things. And so the original email was sent to Ms. Baker, and at one time, Ms. Ross was also represented by an attorney named Elick. So this original email got sent to Elick and Anderson. And then when we saw that it shouldn't have been sent to Mr. Elick, it was sent to Ms. Baker. And in that email, there's some discussion about setting both cases. And are we still on trial for the mail trial date? And if we're not, then we'll need to reset that. On April 28th at 12:04, there was an email, from Ms. Baker to the court, and then to Ms. McCausland, who works for Mr. Anderson. And in that email, Ms. Baker said, we agree to reset both cases. On April 28th at 12:07, there was again an email from Ms. McCausland to Ms. Baker and the court saying that we again agree to reset the cases. On April 28th, 2020 at 2:46, there was an email from the court to Ms. McCausland and Ms. Baker proposing trial dates in July. On April 29th at 9:02, there was an email from Ms. McCausland to the court and Ms. Baker confirming the dates in July. On April 29th at 9:21, an email from Ms. Baker to Ms. McCausland and the court confirming the trial dates in July. And on April 29th at 9:40, an email to the court, an email from the court to Ms. Baker and Ms. McCausland confirming the July dates. So again, that's sort of for Mr. Thorstrup's benefit, kind of how we got to having two cases. But Mr. Thorstrup, I'll turn it over to you.
Judge, if I may briefly.
Right, Judge.
Judge, if I may briefly, the reason that we proposed doing them at the same time was due to the fact that the same evidence pretty much was going to be used on both cases. It was efficient for the court to put them together. It did not prejudice Miss Ross in any way, and it just saved all the parties time and money and the court's time. So I just wanted to put that before the court and Mr. Tholstrup.
All right. So, Mr. Tholstrup, you may proceed.
Certainly, and Your Honor, I appreciate judicial efficiency and economy and all of that sort of thing. So I don't take any exception to that. What I'd like to do is, even though, may I share a screen, Judge? I just want to put 156-101 up there, and then these are just a couple of demonstrative aids, just to be able to make the points.
All right.
Says you have to enable it, Judge.
Oh, so you have to tell me how to do that.
I don't know. We're all learning Zoom. So
When I look at the bottom of the screen, I see mute, stop video, security, participants, chat, share screen.
try share screen, Judge. See if you're the one that can enable it from there.
All right, so when I click on that, I don't know if everybody can see what I'm seeing.
Judge,
And I don't know who's talking then, but we can't hear anything.
Share his own screen.
And we cannot hear anything that was just said.
It's up to Mr. Thorstrup to share his own screen, Judge.
And I agree with that. I understand that, Judge, but it says host disabled participant screen sharing. I'm a participant, not the host, but so I can see that, Judge, your screen is coming up, but that's not. Yeah, I can try this maybe without it. The first thing I wanted to do was just put up a brief. Joe has put his finger up. I don't know if he can't hear or what. Okay. I think you have to unmute, Joe. No. Joe.
It's okay.
Yes. Do you know how to enable screen sharing?
Oh no, I just the host. I don't know if it's a co-host, but there's some sort of accessibility to be able to do so, but I'm not exactly sure.
All right. Well, let me see if I can wing this then, Judge. So the first thing I wanted to do was just go over 156-101, the grounds for modification of order establishing conservatorship or possession. So the modification grounds. And even though, the court and Mr. Anderson know this, the first one of those is the circumstances of the child, the conservator, or other party affected by the order have materially and substantially changed since the earlier of the date of the rendition of the order that's to be modified. Did we lose? There, no, there. And so that's the backdrop. And then when I look at these cases, Judge, the second screen that I wanted to share was for the 2012 case. That last order there was July 1st, 2015. The petition to modify was filed September 13th, 2019. So those would have been the dates as far as material and substantial change goes for that particular case. Now for 2015, the last order entered was May 31st, 2017. And the petition to modify was January 20th, 2020. So those would have been the dates, if you will, to look at the material and substantial change. Now, and I wasn't there, you know that, but evidence would have had to been presented of what the circumstances of the respondent were and or the respective child as of the first order, which was July 1st, 2015, and at the time of the second order, which was May 31st, 2017. So what were those circumstances that immediately following the entry of those orders, and how were they changed? And then evidence would have had to been produced that circumstances with regard to the respondent and or the respective child at the time of the petition filed in September of 2019, as well as at the time the petition was filed in January 20 of 2020. And in this case, the evidence, and I understand that the prior lawyer may have agreed or may have waived or that sort of thing, but the evidence prior to the May 31st, 2017 order would have been res judicata as to the 2015 case, because that's the last order in that case. So presenting evidence of circumstances on the 2012 case in 2015 would have been res judicata. I don't know that there probably weren't any objections, but it certainly that's it. So I get that the judicial economy and that sort of thing, but the case that Mr. Kingsbury cited, this Dow Breyer Court versus Basket, talks about consolidation of cases, and I'll just go through that since I can't share it. The judicial economy and convenience may be gained by consolidation, must be balanced against the likelihood that consolidation may result in delay, prejudice, or jury confusion. If the convenience factors are substantially outweighed by the risk of an unfair outcome because of prejudice or confusion, then the trial court abuses its discretion in granting that consolidation. Now, I've done these kinds of cases where there were two fathers, two children, and so there were parallel cases. But in those cases, mom had been indicted on some criminal matter, and that, whatever that material change was, which was that indictment, it couldn't be cured. In this case, I'm not sure whether the material and substantial changes alleged could have been cured between the one filing of the petition in September and then the second filing of the petition in January. I don't know. I would suspect that, and I have a great deal of respect for Mr. Anderson. He and I concluded a case this last year and had a very professional relationship. So I have no doubt but what, he gave it his best shot there. But how you present evidence on these immediately following the last two orders in two cases, and then the material and substantial change at the filing of the petitions to modify and keep that straight, seems like that would be a difficult order, if not impossible. Again, if the material and substantial change that was being alleged was not curable, and in my understanding, in this case, it wasn't something like a criminal indictment, as an example. If mom would have been criminally indicted and that was going to be going on for some time, then those kind of changes couldn't be cured. In this case, I'm not sure that they couldn't have been. And I don't know if there was evidence put on that they had been or that sort of thing either. But the problem that I see in the consolidation on these two family law cases or 156-101, where you have two separate orders that are, a couple of years apart, and then you have filings of petitions, or they're not that far apart, but they are 4 or 5 months. And so I believe that if the evidence, some of that evidence is going to be overlapping. I'm not saying that wouldn't be the case. Certainly there would be some evidence between 2015 and 2017 that ought to be kept out of the 2015 case, and based on res judicata. And so in this particular case, I believe that the convenience factors were substantially outweighed by the risk of confusion, prejudicial confusion. When are you putting evidence on? Again, I have all kinds of respect for Mr. Anderson and his trial abilities and that sort of thing. But, and yours too, Your Honor, I'm not saying, but given those dates and the requirements under 156-101, I don't see how even the best of the best could avoid that confusion and the prejudice that would result. And I think, you know, if there's a basis for a motion for new trial, that's it.
Mr. Anderson, any response?
Judge, consolidation, but must be balanced against the likelihood that consolidation may result.
And I tell you what, Mr. Anderson, I think we lost you at the beginning. So if you want to could start over for the record.
Yes, sir. I'm sorry. You know, he argues that res judicata and evidence, but that wasn't even pled in this motion for new trial. So to use that would be improper based on it's not pled. Second of all, I believe the court has the ability to consolidate cases by looking at it and seeing if judicial economy would be best served by consolidating them. We had where we had each witness come up and didn't overlap the witnesses. So I don't think that the court was confused at all by any of it. I think we kept it pretty clean, and this thing went on for 11 days. To have another trial for 11 days just to repeat everything would have been crazy and would have been totally against the judicial economy and convenience. So I believe that the court did the proper thing by consolidating the case. It was never objected to. In fact, it was agreed to by opposing counsel. So therefore, they waived that argument that it should have been consolidated. If they didn't want to consolidate it, they should have waived. They should have made a motion before we even went to trial.
And to Mr. Thorstrup, just have a question on the case that was cited again by Mr. Kingsbury, and you talked about, you know, that was a jury trial. So
That was a jury trial.
right. So do you see, you know, a difference in, you know, the level of confusion between a jury trial and a bench trial when you're talking about a consolidation issue?
I do see a difference, Judge. I personally, although the jury has its place, certainly I trust the court to be able to sort things out probably better than 12 people who are not versed in the law and et cetera, et cetera. So I'm not saying that there isn't a difference there. There is a difference. I quite honestly haven't looked at any other case law in that regard. You know, it's one of those kinds of things. This is a case of first impression, at least on my end. As I say, I've done these kinds of parallel modifications before, whenever, especially the best example I have, Judge, is whenever mom gets indicted for criminal behavior, okay? And they proceed separately, but they were filed in different courts. So too, Judge, you know, if say, for instance, in Harris County, the likelihood of both these cases being in the same court would have been very low, all right? Or so any other county. It just happened to be that in this county, and these two cases were in the same court, and I get that. And it's, you know, it's a question I've never had to address before. But I go back to the requirements as far as proving up material and substantial change and proving up the facts immediately following the entry of those prior orders, as well as the facts at the time of the filing of the petition. There are more likely, there are some distinct differences. Now, maybe that evidence was put on properly. I don't know, Judge. I'm not going to even speculate there. All I know is, given those 4 dates and the evidence that had to be provided, it would be extremely difficult not to provide some confusion that could prejudice my client.
All right. So, Mr. Anderson, anything else?
Judge, we would just ask that the court deny their
motion for new trial. There was no confusion. Court, the evidence was pretty clear. There was hundreds upon hundreds of exhibits that were put on. There were two separate exhibit folders for each different one, so where the court could go through the evidence without it being confused. We kept it very organized for the court. And so I believe there is no confusion. We were asking the court to deny the motion for new trial. To have to go through another 11-day trial based on nothing would be prejudicial to my clients, and it wouldn't be effective for the judicial economy. That's all I got to say, Judge.
All right. And now, Mr. Thorstrup, there were other grounds that were raised in the motion for new trial. Are you going to proceed on those or just go on the one you've talked about?
Just on the consolidation, Judge, those ancillary issues, although I might agree with them, I don't know that, that those certainly might have been waived if they weren't objected to at the time. Okay, so those are really what I would consider some sort of civil ineffective assistance of counsel, potentially, from what I can read. I don't know. I don't want to cast any other attorney in a bad light, but those issues, as I've read them in the motion for new trial, are more along those lines. And I'm not those. I think, as I say, just get us lost in the woods at this point.
All right. Well, anybody have anything else then? So if not, then the motion for new trial is denied. And if there's nothing else, this hearing will be recessed. So we're off the record. And as far as the attorneys, before the attorneys leave, have a procedural matter may want to discuss with both of you, just to see how you think it'd be best to be handled. Since these are two different cases, I'm going to assume that Mr. Thorstrup will proceed with an appeal. Since we have two different causes, typically what happens here, and Mr. Thorstrup says, I don't think I've ever met you before. What county do you practice in?
I'm primarily in Harris, Judge, but I live in Montgomery, so I do a fair amount up there, and then a fair amount in Fort Bend as well.
Okay.
So I think I may have made it to Austin County once.
Okay. So just to kind of let you know, Austin County, as far as courts of appeals is concerned, we are in the 1st and the 14th Court of Appeals. And I could tell you, as a practical logistical matter, the way the clerk here handles appeals is they sort of keep a list, and the first one goes to the 1st, and the next one to the 14th, and the next one to the 1st, and they just alternate. So under normal circumstances, what would probably happen is, I'm just going to say that the case involving Presley is 2012. It's the older case. So let's say they would normally send that to the 1st Court of Appeals. And then when they start working on the next one, which is Briley Machacek, they would send that to the 14th. And, the clerk is just doing this, purely as an administrative, that's just how they do things. And so I think I could, request from the clerk to do one of two things. Either let's send these both to the same court. Now, they will have different cause numbers, obviously.
Sure. Certainly.
And I think we've lost Mr. Anderson. So I don't know if we can get him back, but while he's trying to get back, Mr. Thorstrup, I'll just hear from you first. Now typically, when cases are sent to the Court of Appeals, there is a little box that has to be checked. Is there a companion case?
Right.
And I would think, these cases should be considered companion cases. And yes. I would, again, if the argument's going to be they shouldn't be consolidated, I would sure think it makes a whole lot more sense that they're both in the same court. But if you want to request something differently, then I can just tell the clerk, follow your normal procedure.
No, I'd like them to be considered in either the 1st or the 14th, one of the two. I think it does make judicial economy for the, an appeal to be in the same court.
Okay.
I do
All
think
right.
that.
All right. Well, I mean, I think I can just request, let me see if the phone in the courtroom is ringing. If you can get that just to see if that's John Anderson.
Well, there's a box, Judge, that shows John's iPhone too. I'm not sure what that means.
Judge, that means he's waiting to come in. I believe you have to accept him to let him in.
Okay, let me see if I can.
Yeah, you've been bouncing around. The picture keeps bouncing all around. Yeah, go ahead and try to reconnect.
Yeah, see, when I go up to, okay, I think he's,
There it is.
okay. So Mr. Anderson, I get you to unmute. He's not on the phone anymore, is he?
No.
Okay. So Mr. Anderson, I don't know if can you hear me? Because I see that you're still muted.
Yes, sir. I can hear you.
Okay.
I can hear you.
So, I'm not sure at what point we lost you. But I basically said that the clerk's general procedure is just to alternate cases. But when cases are sent up on appeal, there is a box that's checked. And I think we lost him again.
Nope.
Okay. That said, is there a companion case? So, and one choice is one case goes to the 1st, one case goes to the 14th. And in both cases, it's checked there's a companion case, or they both get sent to the same 1st or 14th. I'm not sure which one is next in the queue. And that's up to the clerk. So, Mr. Anderson, what's your thought?
Judge, I think as long as they connected as companion case,
We can't hear you.
I think we're okay.
Well, we can't.
mean-
I can't hear what you're saying.
John, do you have a problem with them both going to the same Court of Appeals?
Can you hear me now? Hello?
We cannot hear what you're saying.
Can you hear me?
Yes.
Not very
Judge?
well.
No, I do not have them. I do not have a problem.
All right.
No, I
So-
don't.
All right.
Can you hear
So,
Yes.
me? I said I do not have a problem with them going to the same court.
all right. So, I'm going to give the clerk a little heads up that if, a notice of appeal is filed, and as she's preparing the documents to send, again, they'll be sent, in 2 different cases. So it'll be up, obviously, to the Court of Appeals whether or not the same panel hears both cases. I can't do anything about that. But whichever one is next, and I have no idea which one's next, I'll just ask the clerk send them both to the same place, but they will be marked as companion cases. And I'm not sure how that gets handled with Court of Appeals. Maybe if they get a companion case, they refer them to the same panel. I don't know.
Great, Judge. That's a very good consideration. Thank you for that.
All right. So anything else?
That's it.
Thank you.
All right.
Thank you, Judge.
John, good to see you too. Both the judge and John, Merry Christmas and Happy New Year's.
Happy New Year.
Good seeing you, Richard.